And trust me, they are starting to listen to these notices.
Do different courts around the country get together and have meetings and swap notes?
Definitely, okay, you've got the district judges which may cover multiple districts. So when we section, okay, to hold the court to account in the magistrates' courts, we've got various tools at our disposal. Okay, and the most powerful tool is what's section 111 of the magistrates' courts Act. And what that is, we're forcing the court to explain how they reached the decision. What did the judge tell you, Lance, when we asked them to explain the decision?
From memory, he doesn't have to explain anything. But
Yours.
Yeah.
That's basically what they said. Forget it, I'm not explaining the decision. Why? Because they know their decision's wrong. So we've got to try and force them and commit them in writing so that we have the evidence. Because then with that evidence, we can bring a private criminal prosecution.
So, with such a case, I'm in the magistrate's court, and the magistrate has said, I'm not going to explain my decision to you.
You have to.
Would my next comment say, well, can I quote section 111 of the Magistrates' Court Act?
You're obliged to. Now, we've got to, I haven't gone through the equal treatment bench book very much. I can tell you, somewhere in their rules it says they must explain their decision in legislation and legislation-derived regulation. Somewhere in there it'll tell you. We need that section. So basically with access to the courts, under the rules, Magistrates Court Rules 66 A, B and C, I think it is, don't worry about it, it's all in there. It says public access. So if you deny me access, you're in breach of your own rules. And since, in my first hearing, the security guard wouldn't let me and Ahmed into the court. Okay? And so we said, you know, who are you to say that? Aren't you familiar with the law? With open justice, every member of the public has access to the public gallery. No, you can't go in. Okay? And so basically, I went back, I pulled out, because I don't know all of them off my head. Basically, I pulled out the case law and pointed it to her. And at this point, you know, there were maybe 30, 40 people in the thing, and we were outside the court door. And to push a point, I'll raise my voice, but I'll still try and be polite. And same thing with Ahmed. And so we asked her, what's your name? She refused to give the name. You have to give your SIA identification number. And this was getting quite loud. And the clerk walked out of the court like, what the hell's going on in here? And so we just turned around to her and said, this woman is denying us access to the court. We've shown her the law. And the clerk just turned around to her and says, you have no right to deny public access to the court. And we went. No problem. Okay, but this is about standing on our rights, but we stand with knowledge.
Yeah.
We have standing. It's no good just saying, oh, the open access to justice principle. Okay. So that is the due process of law. Everybody should have access to courts. Why? Courts are foundational. Without that foundation, money is meaningless anyway. Therefore, how on earth can money be related to getting to court? It's the foundation, the law. That creates any value to money. Therefore, the foundation is moneyless. However, if you're bringing nonsense claims against people, you are knowingly breaching their peace. Okay? And you might not knowingly, but if they point out to you that it's utter nonsense what you're doing, now you are creating a liability on them to defend themselves. Okay? And Lord Mansfield in 1762, in yet another family squabble over property, said, no man can use their inequity as a defense or a cause of action. I.e., if I do a wrong, I cannot profit from it in any manner, which is perfectly rational. Okay? So the due process of law is foundational, and that is how simple it is. We all should be able to go in court. If we bring rubbish claims, and vexatious they call it, okay, baseless claims, i.e. we don't have reasonable excuse to breach their peace, we are forcing them into a position where they need to defend themselves, and that may cost money, therefore that we should pay for that. If we followed the due process correctly, our pre-action protocol, we've done everything humanly possible to settle the dispute before we go to court. Guess what? So long as we can show we've done everything reasonably possible, even if we lose the case, we don't get costs awarded against us. Most people don't know that. Okay? So the pre-action protocol is incredibly important. Do your paperwork right, and so long as you were reasonable in what you've done, no costs. And so the important thing is, it can only be deduced by the evidence presented before it. I'm not interested in the judge's opinion on law. I'm interested between the person who's taking me to court and me. That's the law. And that's the evidence. So when the judges, so what they do is, in the magistrates' courts, the legal advisor advises the court, because they're lay people, the magistrates, with the law, all relevant law and procedures. They're under an obligation. So what we did was we noticed them. However, we've learned from that now. What we do now is we give it to the legal officer and ask the legal officer, can you confirm the Bill of Rights is current statute law? To the bench, please. Because they're ignoring us as litigants in person, I think it is. So this way we can close that loop by forcing the legal officer to say yes or no.
Is there a higher standing?
Well, basically they work on the thing as we idiots, you know, you're not legally trained, what do you know? Okay? So, but they'll listen to their legal officer, they must. Okay?
So
now,
is that at the court, the magistrate?
yeah, they used to be called clerks, now they're called the legal
Yeah.
officers.
Right.
So this way, what we did with Lancers, the magistrates knew what we were talking about, I have no doubt about that. Okay? But they ignored it. So I think this way we can force the magistrates, you have to now take heed to the constitutional law. You now have a serious decision to make. Okay? And in there we'll say, can you confirm to the bench that in its first sentence the Bill of Rights says we the people are represented in Parliament by these Muppets, and therefore they are agents, they don't tell us what to do, we tell them what to do. So it's finding ways that we can force them to do their jobs properly, and if they still refuse, they're in contempt of court. Okay? So, yeah.
Would you ever suggest anybody tries to become a magistrate?
Yes, absolutely.
So
Please, people
I've been
apply.
through the process, and
Yeah.
it was super
What-
interesting but crazy.
What you'll find is, I imagine the selection process is quite selective.
It
So,
doesn't make sense at all. I got through to the last round, but
yeah.
looking back at it, it totally didn't make sense what
Yeah.
answers they were looking for.
Apparently it's quite woke.
It's very,
yeah.
it's very well.
Well, when I left university, I tried to get jobs, okay, and some of the jobs went to councils, and unless I was a gay, lesbian black woman with AIDS, you didn't even need to apply. And literally, that's how blatant it was at the time. But
But I
yeah,
think if enough people bombard
so
the system,
the
some
idea
will
is,
get
we'll see
through.
tomorrow with the court auditor is, guess what? We learn what we're meant to do as a jury. We get 12 people into the magistrates' courts, and we become the jury. And that there will override whatever they say in the magistrates' courts. That's what I'm trying to get to. Okay? So multiple attacks. Okay, so you're happy how simple the whole thing is meant to be?
Yeah.
Okay? So just to read you a few quotes from their own rule book.
What page are you on there?
So this is going on to page 20, 19 on to 20. So basically Lord Diplock finished this description by saying anything which goes against this is a contempt of court. So if they don't determine the respective parties' duties, rights and obligations, contempt of court. If they don't reach a decision based on the evidence, contempt of court. Now what's happened is they've given you errors of law or errors of rationality, i.e. evidence. You can appeal. Stuff the appeals, that's playing in their game. We're setting up a new game, okay? We're gathering the evidence and we're going to go straight to private criminal prosecutions. Not waste any more time in their court system. Finished.
Brilliant.
End of. Okay? We gather the evidence, we make sure we've got the evidence, and we start to prosecute them, because that's our right.
Can we do this in a county court? I've got
Any
my
court.
case.
Any court.
Okay.
Yeah. Okay. Natural justice, a few quotes. A decision given without regards to the principle of natural justice is void. Although there exists no clear definition of the principle of natural justice, it cannot be said for this reason, therefore it does not exist. An unbroken line of authority to the effect that an officer cannot lawfully be dismissed without first telling him what is alleged against him and hearing his defense. There are three features of natural justice: the right to be heard by an unbiased tribunal, the right to have notice of the charges, and the right to defend yourself. Administrative courts are unlawful, and basically an administrative court is when somebody does not apply their mind to the evidence and the decision they're making before them. And
But
so,
isn't that all magistrates' courts?
yeah, correct. Because also they're on breach by coming with a presumption legislation is law. That's a direct contempt, because that's a contempt of the judiciary's independence, but nobody's pointed this out to them.
They have. I
Okay.
just haven't listened.
Now, duties, rights and obligation of the court's officers. And this is how equitable it should be. Okay? Misleading the court is regarded by the court and must be regarded by any disciplinary tribunal as one of the most serious offences that a litigator or advocator can do. And such conduct will normally attract an exemplary and deterrence sentence. Conducting the privilege of conducting litigation or appearing in court is granted on terms that the rules are observed not merely to the letter, but in their spirit. Okay? And the standing of the profession depends upon the discharge of the duties owed to the court. That there is pretty damn clear as to what should be going on. According to their own rule book and the Legal Services Act, the overriding principle of any officer of the court is first to the rule of law, the constitutional principle of the rule of law, to the court. And the obligations to the court include that each officer puts the court with all relevant law in favour and dissent of their client's position. So that means the prosecution should say everything in favour and dissent of theirs. The defence should give everything in dissent, in favour and dissent. But they've sold you this thing, oh, hang on, you know, we had fisticuffs, and then we got the sticks to beat one another over the head, then we got the swords, and then we got the pistols, but now we just got paper wars. Bullshit. Both of you are meant to be upholding the rule of law, and both of you must ensure that the court gets all relevant law on in favour and in dissent.
So is this the Legal Services Act that you're quoting?
Yeah. Basically, the Legal Services Act creates the obligation for the privilege, okay? And that privilege then is detailed in their professional standards. So you've got the SRA handbook, the Solicitors Regulation Authority handbook, and the Bar Council, Bar Association, whatever they call it, and SILEX, the Institute of Legal Executives. And the summary on page 22 is in common to all of them. Okay? So it doesn't matter what your legal profession is, this is the minimum of what you need to do. And so then, now they cannot knowingly or recklessly mislead the court. So once you put them with the knowledge, should they continue not upholding the obligations, they really are personally liable. And I've got 4 solicitors in the King's Council on notice. And actually, I'll just quickly say about that. Okay, in a private case about a flat, the developer went bust, and the liquidators are after paying their salaries, and there's £400,000 which really, I believe, we the investors are due, and they believe the bust developers due. And so they do something called a draft reserve judgment. Most people have never heard of this. Many solicitors don't even know what these are. But what they try and do is they give you the judgment in advance, and it seems to be with controversial cases where they know they're wrong. Okay? There's an obligation under their own rules again, that if there's any errors and omissions as an officer of the court, you need to notify the court to correct it, because the overriding objective in the rules, which we'll cover tomorrow, is justice, fair and just. I'm not an officer of the court, and so I sent a copy to the court of the errors and omissions that I found, which basically everything she said to give them the money instead of us the money was wrong. And I copied all the 4 solicitors in and the King's Council. And I said, you guys have a legal obligation. I'm not under a legal obligation. You need to verify these errors and omissions and notify the court if I'm correct. The one woman turned around immediately, she's like the gang leader, and said, we don't believe we're under these obligations. I said, no problem. So I sent the next notice. At the handing down of the judgment, basically, the judge asked me, have you got the judgment? I said, no. And she said, well, we've only corrected typos. I assume you're going to appeal. Hint, hint. And she said, of course I'm going to bloody appeal. And by the time we got home from Crewe, there was an email from Karen, the same girl that said, I don't believe we're under the obligation. She said, now that you've been granted the right to appeal, we assume that you're going to discontinue your notices. Okay? Solicitors know what those things are. Okay? But again, the point being, using their own rules, holding them to account. So far, basically, rule of law, all of this stuff, very good. Do your job, guys. Now, with litigants in person, okay, so this addresses, how the language fraud, legalese, all of those versions about, how wordplay and all of that, okay? This is out of their book, not my book, okay? Take special care when dealing with litigants in person to use plain language and not take advantage by bullying and unjustifiable threats or misleading or deceitful behaviour. So tell me it makes a difference whether you want to call yourself a person or whatever, or play legal fiction, or driving a car, or conveyance, or that there is their rule book. Okay? So what I want people to realise is stop wasting your time where there's no evidence to support a belief, so that we can focus in on the problem. The problem is these guys are not doing their job. Okay, so let's cut the crap. Let's get all our energy going in one direction.
If that is the case, why does the language legalese even exist?
Because this is specific, a special obligation when dealing with litigants in person. Every specialism has its own shortcut terms. So for instance, judicial notice. Okay? Judicial notice is to avoid wasting the court's time by asking somebody to prove the obvious, something that's observable to everyone. So, your claim's based on the grass being green and I've caused you harm or something, okay? Instead of me saying, prove the grass is green, okay? Look, that's our common agreement, grass is green. Therefore, we don't need to waste court's time to prove it. So with Emily's case, in the first COVID case I got involved with, basically...
Using an example,
Judicial notice is the example.
Okay.
Yeah. So basically, we were asked to put in a defence because against a COVID fine, one of her COVID fines, and so because it started at the hearing, okay, but we said we're arguing points of law, not facts. The facts aren't in dispute. She didn't sign the paper when she came back. So. And there goes the judges, God, free land, or common law, or this sort of stuff. So we said, in accordance with the Coronavirus Act, blah, 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 in accordance with the Public Health Act, blah, blah. But you should have seen the prosecution on the video for like, God. But the more we got into it, you could see he's bloody checking what we were saying. The judge turned around and said to the clerk, can you give me my next available date? I want to hear this case. Okay. And so he asked for written submissions, which we had to give a month before the hearing. And the written submissions are basically, they fail to prove lawful cause of action because they've not shown that COVID exists, that it causes unique harm, and that it's transmissible. Therefore, it's all bullshit and irrational and unlawful in accordance with law. Long and short. So when the prosecution presented its case, they turned around and said, we asked the court to take judicial notice of COVID-19. What should have happened was, judicial notice is technical jargon. Unless you're familiar with rules of evidence, you'll never come across the words.
I wasn't talking about those shortcut terms. I was talking about things like the word may means must and must and may.
The same point will come out with this.
Okay.
What should have happened was, I'm the legal officer, I asked the court to take judicial notice. Do you understand what judicial notice is? Okay, same principle applies. If you don't understand what a word means, ask. If you don't ask, those who don't stand on their rights...
You don't know that they're using a different language.
No, it's not a different language. It doesn't matter.
Or they're using a different definition.
If you feel that they are trying to mislead you or trying to trick you, you stop them. Sorry, I don't understand that. Can you please explain, in accordance with your obligations, okay, in your rule book, what you're talking about here?
The trouble with that is you would think you understand the word may,
this is the problem.
and that you don't understand it means must.
No, it doesn't. May means may. It's an option.
It does to us, but in legalese
Plain
terms-
language.
Yeah, but they don't apply that, do they?
There are plenty of court judgments which affirm it's basically O-level English. How would an O-level English, a reasonable person, understand what's being said? Loads of case law to affirm it. Okay? So the word may means, what would a reasonable person understand the word may to mean?
Well, what does the word must mean? Because when we believe that when they say the word must, they're actually saying, you may do this.
No,
There's two dictionaries. We've got the English Oxford Dictionary, and then we've got the Law of Dictionaries.
yeah.
Which we keep
At O-level English at school, do we go through the Law Dictionary or the Oxford Dictionary?
But yeah, that's yeah.
Therefore, the Oxford Dictionary applies. Not
So
the Law
why do we have a
Dictionary.
Law of Dictionaries?
Because, for instance, with judicial notice, okay, instead of the guy turning around saying, do you understand judicial notice?
But isn't that clear fraud where they're using words and inverting
Yeah,
the
no,
meaning?
but this is what I'm saying, okay? What should happen is, do you understand what judicial notice means? And then they should explain it to you. If you say no, to avoid court's time, if that's another lawyer, they don't need to waste time. Hey mate, do you know what judicial notice means? Of course, I've been through law school the same as you, I know what it means. So that's why a technical term, so if they mean the word must in anything other than Oxford English O-level standard, they must explain what it means.
All right.
They
So
have an obligation.
if they know the difference, they must then ask.
They must do it,
All right,
otherwise
but
they are
but they never
knowingly
do
causing
that.
harm.
But they never do that, they'll do that.
Well, I don't know. I mean, I would disagree with that. I mean, I spent a lot of time in courts, and
Okay.
I've never, judicial notice was the only time that that's happened to me. But you're free at any time. If you do not understand, they must explain. Okay? They must. If you don't understand, they can't proceed.
Right at the very beginning, when you're setting the terms of the court and you know you're a litigant in person, maybe you should say something like, well, I'm assuming that we are going to be acting in accordance with
well, on your notices, you
plain
can write
language,
it.
etc.
On your
And
notices,
then
you
they're
can write
told, and if they start to use terms that you don't understand and they haven't explained and they're trying to speak double speak, you've then got them on the barrel because it was agreed at the beginning.
If you spend time in courts, did you experience any double speak or anything like that?
No. No,
Honestly, if you get into court, go and sit in the public gallery and watch what goes on. It's nothing like what they tell you on YouTube. These people on YouTube, it's just giddy. It's opinion.
And equally, and kind of what you're saying over there, you have an instinctual reaction when you think you're being led up the path.
Yeah.
And at that point, you're absolutely in your rights to just go, hold on a minute, what do you mean?
Okay, then the last two obligations are quite simple. They cannot claim something they have no lawful right to claim, and they cannot create a dispute where none exists. Now, if they would do their job according to that list, poor bastards wouldn't make no money, would they? That's the problem. They have a conflict of interest. We want dispute resolution. They need dispute to make money. Yeah?
Just talking about language in court, from my experience, the only words that are really important in court to use and decide the difference between are like and, or, if.
Yeah, and or.
Yeah, because that puts you somewhere doing something. Yeah, so it's like and, or, if, you know, like these kind of words that potentially put you in a position where you're breaking the law, which is what, maybe 6 kilometres worth of legislation.
Yeah, something like that. Okay, can we have a break then for half an hour? Sorry folks for gone over, but we've actually covered stuff that we'll be covering later. So half an hour for some lunch and then